Welcome once again to Lehto's Law. Here's Steve Lehto.
I had a whole bunch of people send me this story, so here we go. Couple left with life-changing crash injuries can't sue Uber after agreeing to terms while ordering a pizza. It sounds a lot like the situation that happened with Disney not so long ago. The court has said that they agreed to the terms when their daughter ordered a pizza on Uber Eats. At least they say it was their daughter who ordered the pizza, but it turns out that the Uber agreements kind of reference each other. So Holly Evans wrote this for the independent.co.uk. A couple left with life-changing injuries have been told they cannot sue the company Uber after being involved in a crash as they'd accepted the terms and conditions in a pop-up when using the app. Now understand, they can still pursue a legal remedy against Uber. They simply have to arbitrate it rather than try it in court. The couple are from New Jersey. They were riding in an Uber vehicle when it crashed in March of 22, and the wife was left in critical care for a week with a spine fracture and traumatic injuries. However, when they attempted to sue the company, state judges ruled they had clicked a confirm button on more than one occasion when asked if they agreed with the terms that Uber was offering them. Speaking to the BBC, the couple said that the most recent time the terms had been agreed to was when their 12-year-old daughter had ordered a pizza on Uber Eats. But apparently, they'd clicked on more than one. So this meant that they were unable to bring their case to a jury because they'd forfeited that right. And of course, your right to a jury is guaranteed you under the 7th Amendment of the Constitution. The wife says, how would I ever remotely think that my ability to protect my constitutional rights to a trial would be waived by me ordering food? Speaking of the injuries, she said that she suffered a horrible post-operative infection and almost died and was unable to look after her child. Her husband fractured his sternum and still doesn't have full function of his left hand. He says he's in pain every day. As a result, they've accumulated a tremendous amount of medical debt and required further treatments, including a possible third operation for the wife. However, Uber had argued that the couple could not take the case to court as they had agreed to the clause in their terms of use. A New Jersey Supreme Court ruling says, we hold that the arbitration provision contained in the agreement under review, which the mother or her minor daughter, while using her cell phone, agreed to, is valid and enforceable. Referring to her daughter's use of Uber Eats, the mother argued she didn't know how it can be right that she is considered to have authorized my child to waive our rights to go to trial if we're injured in a car accident. I don't know how anybody makes that leap. Case has drawn parallels to the controversy surrounding Disney after they attempted to avoid being sued, saying that their arbitration clause in their Disney Plus membership protected them against claims brought by people who visited one of their properties. In that case, a husband had filed a wrongful death lawsuit against the company after his wife died following an allergic reaction at a restaurant at Disney World in 2023. Disney said he'd waived his right to a jury trial when signing up for a free trial of their streaming platform 4 years earlier. And then, of course, there's tons of media coverage, including I did a video or two on it, and they then decided to agree to a trial with a jury. Now, this case, I've seen a couple different versions of the story, and there's Uber Eats and there's the Uber car service. And apparently those are two different apps, okay? And they say, look, our daughter clicked the Uber Eats button. And someplace else I saw that the argument was that they had also clicked on it. But the point simply is, when you are loading an app into your phone and you're firing it up and it says, do you agree to these terms of service? Nobody reads those. But it turns out there's actually important stuff in there that would be helpful if you knew that. The question is, would you use Uber if you knew that if that vehicle gets in an accident and you become severely injured as a result, you can't sue them. You can only arbitrate against them. And one thing you need to know is that arbitration is not an absolute loss for the plaintiff. A lot of people think it is, but it's not. I'm not saying it's as good as going to court. I don't think it is, simply because arbitration often has a streamlined process and streamlined rules. And likewise, there's other things that affect it, such as they'll often say you cannot appeal the arbitration and leave it to where unless there's corruption, like unless you can prove that the other side bribed the arbitrator, there's not much you can do about it. And I've mentioned before that I have had arbitrators come back with rulings both in my client's favor and against my client that were contrary to the law. And I've actually had arbitrators say, well, I'm not required to follow the law. I'm here to arbitrate a claim, which means that I simply resolve this dispute how I see fit. And that's strange. But also, quite often, the corporations that put these arbitration agreements into these documents and these agreements, quite often they'll say, and we get to pick the arbitrator. And that's one I want to talk about, because I had a case once where my client bought a product that had a very, very complicated warranty setup. Let's just put it that way. And there was all these documents and warranty booklets and manuals, and buried deep in one of them was an arbitration agreement. Now, my client never signed it because it was buried so deep in these other documents, but he did sign a document saying, I agree that I've gotten all these documents from the seller. So they said he got the documents, therefore he agreed to the arbitration agreement. And we got this big argument in front of a judge once, and I talked to my client about this in advance. And I told my client, I said, look, judges tend to push things into arbitration if they can because it gets it off their docket. So I said, Your Honor, the problem I've got with this arbitration, among other things, is they get to pick the arbitrator, the rules, all that stuff. I think that's unfair. And the judge goes, well, it does seem a little odd, but do you have a solution? I said, yeah. Let's just arbitrate the claim, but let the two of us pick an arbitrator. And my opponent goes, oh, that would never work. And I go, why not? Why not? And the judge goes, what are you suggesting, Mr. Lehto? I said, well, Your Honor, I go, you've been around for a while, and he had been on the bench for quite some time. I said, you must know some retired judges. And he goes, yes, I do. I go, why don't you give us a list of 3 retired judges? I get to strike one, she gets to strike one, the leftover judge arbitrates our case. Judge looks to the other side and goes, what do you think about that? I like that idea. And my opponent's like, well, Your Honor, I have to talk to my client. Do you want to go out in the hall and call your client? And 10 minutes later, we put it on the record that we'd agree to arbitrate the case by doing what I just suggested. And it was the best arbitration result I've ever achieved. And now, I'm not saying that, anything magical happened. My client had a good case and could have got the exact same result from a jury. May have gotten more, may have gotten less, may have gotten the exact same thing. We don't know. But the point simply is that to try to level the playing field, I said, let's go with an arbitrator that you guys didn't handpick. And they didn't like that idea, but the judge did. And so I've had it happen more than once where we're in a situation trying to resolve something. And I know the judge will agree with me if I throw an idea out, especially if I involve the judge and go, hey, you must know 3 retired judges. I didn't say, hey, the 2 of us will come up with an arbitrator. I said, no, Your Honor, why don't you give us the arbitrator? That way we know it's fair. And I remember getting the list of arbitrators, and I did a little bit of research to find out, if I had to pick among the 3, which is the one I would get rid of. But other than that, had a very good arbitration. And I remember my client afterwards, because my client testified at the arbitration, afterwards going, that wasn't that bad. And it did happen more quickly and took less time than trying a full case. But like I said before, there's inherent problems with arbitration. And the biggest problem I've got is if they're allowed to pick the arbitrator and the rules and the forum and all that, the odds are against you, okay? So they can arbitrate their claim. Their attorneys, most likely, can help them arbitrate the claim. And it's just simply, instead of being in a court, it'll be in an arbitration venue. But, like I said, no appeal. Oftentimes the rules of evidence go out the window. There might not be any discovery, which is extremely important because the other side quite often has all kinds of evidence that you need to get your hands on. And a lot of times they won't have things like that. So there can be problems. But as it is right now, this couple cannot pursue this in court. There's not going to be a jury trial here. At best, they're going to have an arbitration, or they can settle the case. But the thinking of the corporation is that an arbitrator is less likely to throw money at somebody because they're hurt. They think an arbitrator is going to be more even-handed and cool-headed about that. So from the independent.co.uk, Holly Evans wrote that. Couple left with life-changing crash injuries can't sue Uber after agreeing to terms while ordering a pizza. That's the argument. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. A programmer is someone who solves a problem you didn't know you had in a way you don't understand.